I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Today, and we have a very special guest coming from New York. We have David Fish on the line. David, why don't you tell us a little bit about your practice?
I guess my practice is a little unusual in kind of the time of specialization, where I think a lot of people are heavily specialized in one area of law. I certainly do a lot of employment law, but I'm also involved in commercial litigation, criminal defense. I represent athletes. So I do a fair amount of different things, and I have a decent amount of trial experience as well. So definitely heavy employment law, but certainly trials and in other areas as well.
So speaking of athletes, you like to term yourself the MMA lawyer, is that right?
That's sort of the moniker or the nickname that I've gotten, and it's kind of gotten a little traction. So I like it. Yeah, I do a lot of work for mixed martial arts athletes. A lot of people think of the UFC, and it's that kind of fighting and integration of a lot of different styles. So I've been working with MMA fighters for a while, and I really enjoy it.
So what kind of law do you do for MMA fighters?
Well, when you say law, it's kind of like what some of my law students say, what is sports law? I don't know that it necessarily falls under any real body of law. What I do largely is help promote them and work with fight promotions. So I try to secure contracts for them. I review the contracts, negotiate the contracts, work with them on their medicals, and all the things that surround fighting. I mean, my goal, and it's similar with my non-athlete clients as well, is I try to take the burden off them so they can focus on their work, their training, their nutrition, their friends. They don't have to worry, their family, and they don't have to worry about all the other nonsense that surrounds being a fighter, and particularly a professional fighter. It's a lot of work. And
yeah,
my goal is to sort of take that off their plate.
So when people ask me as an agricultural lawyer, what is agricultural law? I mean, it's as an industry-based practice as opposed to practice area-based practice. It touches on everything, including criminal law. So I imagine it's a little bit along the same lines. All right. Well, today's focus is going to be on employment contracts. And I'd like to first address a common question that I'm asked. How do you know if somebody is an employee versus an independent contractor?
That's a very, very sort of active area. And the answer isn't super easy, because there really isn't a bright line rule where these people are employees and these people are independent contractors. There are a lot of factors that go into that, but I'll still try to answer that the best I can with sort of this mishmash that's out there. I guess there's sort of three general areas to think about when you think about whether someone's an employee or an independent contractor. It's sort of the behavior or behavioral tests, financial tests, financial control, and then sort of the real nature of the relationship. Is there a contract that actually talks about what the relationship is? So the behavioral stuff are things like, and I don't want to call them an employer, it's easy to call them an employer, but that's what we're trying to figure out. Is the entity that you're figuring out whether it's an employer or just an organization using someone as an independent contractor? Does it tell the person their hours, where they have to work? Does that entity give them equipment to use? Does it review them? Does it train them? Those are generally some things that you look at under behavioral. And then I'll sort of bring this back to a practical sort of perspective after. The financial issues. Are they actually paid as a W-2 employee, or are they paid as a 1099 independent contractor? And those are just IRS forms for people that aren't super familiar with that. are they paid in a lump sum after a project, or are they paid as traditional employees are paid every few weeks? And then you look at, and none of these things are determinative, and this one certainly isn't determinative. Is there an employment contract, or is the person treated as many of us are, which is at-will employees? You come to work, and you could leave anytime. They can terminate you at any time. Is there a document that sort of covers that relationship? Were they given an employee handbook? And I guess the way I would sort of give an example is, if you're a company, maybe in a small companies often will do this. They may bring in, for example, an accountant or a bookkeeper to audit their books, or give them advice on how to handle their business systems or their employee payroll. That person will come in, and she may look at all their documents and come in and ask for things, and come in at the time she wants to. She might come in on a Saturday, she might take the work home. No one's training her on how to do her work. No one's reviewing her. She's taking a project for this employer, but not really as an employee. That really sounds like an independent contract. Now, where it gets tricky, and I advise a lot of employers on this stuff, is let's say you bring in someone like that, and you say, listen, we'd really like you to use our equipment. We're going to give you a laptop. We'd like you to be here from 9 to 5 because, we're going to have questions to ask you. And we'd like you to do this. We'd like you to use this paper. We'd like you to use this method of accounting. Suddenly now you have a lot of control over how that person is doing their work. And it's starting to smell more like an employee than an independent contractor. And what I would say is that those are the factors that the IRS, or I'm in New York, the New York State Department of Labor, or other agencies are going to look at more. In other words, they're not going to let you treat someone like an employee and then say, well, we're giving them an employment contract, and we're paying them as a 1099 independent contractor. Because those are things that certainly can be manipulated by an entity. They could actually, so again, what the question is going to be is how are they really treated, rather than do you manufacture a relationship that really isn't there? Yeah.
So along the same lines, what risk does an employer have if they misclassify an employee or versus an independent contractor?
Well, there could be large amounts of money that are due. And what do I mean by that? If someone is truly an employee, an employer has, and I don't want to hold myself out as a tax expert at all, but certainly they have income tax withholdings they have to make. There are Social Security and Medicaid and other types of payments that are required. Unemployment insurance, workers' compensation, things that you need to have in place for employees. So you're going to owe that money. And there may be penalties and fines depending on willfulness. But I will tell you that even for small employers, I've had very small entities come to me with hundreds of thousands of dollars in fines and money owed. And they come to me and say, what am I going to do here? And in some cases, it's a matter of challenging the fining, whether they were an employee or an independent contractor. Sometimes the entity seeking those fines is just wrong. Or at least there's a good faith argument we can make that they were acting properly. Sometimes they just screwed up. They didn't get good advice before they came to me, and it's a matter of negotiating those fines down or entering into some kind of payment plan. So the risk is real and serious, and I can tell you that in New York, the Department of Labor and other agencies are actively looking into these things and fining entities where they believe that they're misclassifying employees as independent contractors.
So what do you tell employers when nobody has thrown up any red flags? They're not in trouble. Nothing has happened, but they believe that they've made a mistake, that they're paying somebody as a 1099 independent contractor, and they probably should have been paying them as an employee for maybe a few years now.
Yeah, it's tricky. I say it's tricky, but my answer is sort of clear on this. The answer is you do the right thing and you properly classify them. Why do I say it's tricky? It's because, you're always trying to help your clients and reduce exposure. And in doing that, you potentially put up a red flag to the existing employees. Well, they're suddenly changing things. Have they been doing things wrong? Am I entitled to something? Sometimes you'll get an employee who maybe isn't particularly happy, and they will reach out to an agency. And you sort of open up the door to potential fines or liabilities. But my approach always is, you act in the here and now. And if you can correct something now or do something right now, you're better off doing it. The alternative is, you sort of live on pins and needles waiting for something to happen. And when that thing does happen, you suddenly create so much more liability going back. I mean, sometimes you need to say, I did something wrong. I did it in good faith. I just wasn't advised properly. And I may need to pay a little something now for that, but it's better than the harm that can come if an entity knows you knew what to do and you willfully ignored what your obligations are, and you let this go on for years and years. I mean, these kinds of things could put businesses out of business. So my thought is always correct it.
So just a few weeks ago, I was at a CATA conference, and one of the ag producers came up to me and was like, hey, Carrie, but payroll is such a pain, and what advice do you have for clients who are maybe startups? They've hired their first farm employees, or maybe they're a growing agribusiness and they're just getting the ball rolling. How do you sort of ameliorate that pain of payroll?
Yeah, I mean, I'm very sympathetic, particularly to small businesses. A large business, they hire out one of these payroll services and it's all done, and it's an expense typically that isn't significant. Whereas small businesses, and you and I know, both advise a lot of what would be considered small or medium-sized businesses. This is an expense. It really is a necessary, though, part of doing business, and an expense that I really think you need to incur, because the cost of not doing it and the pain of not doing it is going to be a lot greater. So one, I would say that it is really not as difficult as people think to do, to set this stuff up on your own. And there is a lot of sort of guidelines and help you can find online for free about doing it. But if that's not really within your wheelhouse and you don't want to do it, I suggest hiring one of these payroll companies. And, you don't even have to go to some of these larger ones. I mean, I know just from my own experience that there are a lot of small payroll businesses that are looking to grow and to take on small clients, and will often do it at a fair rate to sort of get you on board and to build their business. I'm really a believer of doing things once and doing them right. Take the time. I know it's not going to be fun. You're going to have to spend half a day or day on the phone with this new company and getting this payroll done. Do it right now, and you're not going to have to think about it again. So I would strongly advise people to get it right from the start. Go through that.
I definitely agree. So let's talk a little bit about employment contracts. In its simplest definition, what is an employment contract?
So a contract is making a private right enforceable, right? If I had to define a contract, right? We all have rights that exist without contracts. We have, the right not to be touched without our consent, right? We have the right to be free from assault. We have the right not to be defamed, not for someone to make a false statement of fact about us that's going to cause us damages. These are things that exist without any contracts. A contract is creating a right between two people or entities that doesn't otherwise exist. So to put that in the employment context, most employment in the United States, and I'm not even sure if the At-Will rule doesn't exist in any state. I mean, I practice primarily in New York, but the other states I practice in, it's At-Will employment. So that means me as an employee, I start work, I can leave my employment at any time I want for any reason. That employer can't do anything to me. An employer can terminate me at any time for an arbitrary reason, for no reason at all. They don't like the way I combed my hair today. They can terminate me. Now, this isn't for this topic, but of course there are anti-discrimination laws and other laws that prevent discrimination based on certain traits. We're not really talking about that here. So to get out of that At-Will rule, for me as an employee to have extra enforceable rights, for the employer to have extra enforceable rights, we enter into a contract. We agree that we're both going to have protections that wouldn't otherwise exist under just the at-will employment rule. And those may be what my salary is going to be. Are there going to be changes in my salary and benefits? How long am I going to work? Am I guaranteed a certain period of time that I will work and receive a certain pay from the employer's perspective? And again, I'm keeping this fairly simple. The employer may want certain protections that if I'm going to leave, I have to give a certain amount of notice. I think there's a myth that it's required under the law that you give a certain amount of notice. Not true. You walk out the door. Employer might want some kind of notice. The employer might want some guarantee of some type of transition plan. The employer might want to know that when I'm working for them, I'm not going to be working anywhere else, particularly for a competitor. They may want to know that when I leave, I'm not going to work for a competitor for a certain period of time. So an employment contract gives both sides rights they wouldn't otherwise have and gives them certain benefits that they find important to them.
So if an employer just emails a new hire or text messages, does that form a contract?
It could, because a contract, a contract doesn't have to be a long document written in legalese, and hopefully it's never written in legalese. But a contract can be, you shall do this for me, and I shall do this for you. That's a contract. If that is written and the parties acknowledge it, that's a contract. The reason it's not a great contract is there's just so many sort of sleeping dogs there that can wake up. I mean, issues, sort of things that we talked about. What's the rate of pay? When are people going to be paid? How are they going to be paid? Do they have time off? What are their hours? What's the term of the agreement, right? There's so much that there's so many important elements that you'd want to add. Now, you say if someone emailed me, if someone put all those details in an email and to me and wanted to hire me as an employee and I acknowledged them and say I accept and began working under those terms, that's a contract. That's a contract that I would argue is an enforceable one.
So how does an employment contract differ from an employee handbook?
An employee handbook generally is an outline of the protocol, the rules and rules and responsibilities of an employee, and it can contain things that are contractual looking. But outside of that document stating, this is an employment contract for X, Y, and Z, and you signing and acknowledging that, I would argue in most cases an employee handbook is really just more of the rules and regulations and conduct that's expected. Now, the importance of something like that very often is that in an employment contract, we didn't talk about this part of it, it will give the grounds under which an employer can terminate the agreement and often the grounds under which an employee can leave. So one of the things an employer may say is that it may reference this employee handbook and say one of the grounds that we can terminate you for a cause and not just we can show you the door and not have to pay you is violation of the rules and guidelines in this employee handbook. This is a little bit of a nuanced area of the law. I can tell you in New York, there have been some cases where at-will employees have argued that a particular employee handbook created a contract. And the only way I would really answer this is that it really is case by case, because some employee handbooks are just truly employee handbooks. This is the rules of conduct. These are the things you do in different situations. Mm-hmm. But it starts off saying, you are an at-will employee. This is not an employment contract. Exactly. Whereas other employee handbooks may really toe the line. And there may be language in there that sounds like it's forming an employment contract. So, it's a case-by-case thing. And I think what employees want to do is really understand what an employee handbook is saying. Is it creating an employment agreement? And employers should be very careful if they do not want to create an employment contract for a fixed term where they have to pay people, even if they want to let them go without cause. What does that employee handbook say? Is it clear that this is an at-will employment relationship and this is simply sort of guidelines for how to conduct yourself in this workplace.
Yeah, I had a client who their employment handbook had a confidentiality clause in there, but they thought that that was sufficient. They didn't have to have a separate non-disclosure agreement that was signed by the employee. And so I think that there's a lot of confusion in there on whether or not the employee handbook is actually binding.
Well, the thing that you raise is interesting, and I don't want to get too nuanced here either, but if you have an at-will employment relationship, and it's understood that way, and then suddenly the employer adds into the mix some type of obligation on this employee, confidentiality, non-compete, you're asking that employee to do something. This consideration there, right? That's a big contract word, consideration. You need consideration between the parties, an exchange of something of value. They're asking for something of value. What are you getting of value? And is that a real contract? And that's been an interesting question when an employer asks for something like that and doesn't give, for example, a raise or something else of value. What employers have argued, and again, I don't want to get too much off topic here, what employers have argued is that because it's at-will employment and we can terminate you at any time for no reason at all, us continuing your employment is the consideration.
Mm-hmm.
I think that's a rough argument, but it's carried in some jurisdictions. Yeah.
So do you think that all employers should use either an employment contract or independent contractor agreement? I mean, do you think that in all situations these need to be in writing?
I mean, it's the boring, unsatisfying answer of it depends, right? It really does depend. But I guess what I would say is unless an employer wants something very specific from that employee, a guaranteed term of employment, or certain restrictive covenants like non-compete or confidentiality are particularly important, I think an employer has more freedom without an employment contract. Because under the at-will rule, if you want to make a change for business reasons, you're unhappy with performance, you feel like you can hire someone who's superior, you have that freedom to do that, but if you want to lock somebody in, you get an employment contract and you set a term.
Are there any other disadvantages in having a written employment contract? Would just be like that lack of freedom to be able to fire somebody because they wore red on Tuesday?
Well, I think the one thing is that very often in an employment agreement, unless you have cause, and again, cause it can be a vague thing, and what rises to the level of cause, what level of misconduct or insubordination creates cause, it can be a question. But if you want to let someone go without cause, you may still have the obligation to pay them their salary and benefits throughout the term of that agreement, a year, 2 years. So you give yourself a large financial obligation. Other disadvantages to having an employment agreement. I wish something jumped out at me right this minute. I can't think of something that jumps out other than sort of that obligation that can be significant.
So when you're drafting employment contracts for clients, what in your mind are sort of the major provisions that need to at least be addressed?
Well, when I'm drafting an employment contract, it's usually when I'm working on behalf of an employer. I work for both sides, but an employer, I can't remember an employer ever coming to me and saying, hey, employee, draft us a contract. I'm doing it for an employer. I think the key from the employer's perspective is you want very wide latitude. You want great discretion in what you can use to terminate the agreement. I want, any conduct that the employer finds is not in its best interest. Some kind of broad thing like that, which basically means anything, right? If I'm an employee, I want a very specific list of things that are termination for cause, right? Conviction of a felony, theft, assaulting another employee. I mean, I'm just making these things up. The point being that I know that unless I do A, B, C, and D, I'm protected. I'm not going to lose my job. And in addition, that magic, sort of legal phrase, including but not limited to, right? So as the employer, I want including but not limited to. I want an open-ended, non-exclusive list of things I can use to terminate an employee. If I'm an employee, I want a list, and anything that's not on that list, I'm safe.
Well, how much negotiation power do you think employees really have? If you flip the table, an employee comes to you, do you believe that that those contracts can really be negotiated?
The short answer is no. I mean, unless you are a unique, incredibly valuable, and we all think we're unique and valuable, but we're not. you know, you really have very little negotiating power. I think, and I talk to my students about this when we're talking about contract. I teach at New York Law School, and I've been teaching drafting contracts for a long time now. And we talk about negotiated versus non-negotiated contracts. You certainly can negotiate anything, but I give them the example. You're applying for that firm, you're in your last year of law school, and you've been interviewing for that firm, and finally you sit down with them at this last interview. They say, we're going to hire you, and they slide that contract in front of you. You're not redlining that contract. You're not saying, I'm going to look at it, mark it up, and get it back to you. You're saying thank you, and you're signing your name. So while anything can be negotiated, the reality is the employers have the power, and typically you're just signing on the line that is dotted, right? I mean, that's what you're doing. An easy example, and in the sports world, is highly coveted athletes have great negotiating power because there are competitors that are willing to pay them a little bit more, right? So when you are such a unique, specialized person, that's where you have a little bit of negotiating power. But beyond that, it's very little power I feel that employees have.
So going back to compensation in agriculture, sometimes people are paid in-kind compensation. They're paid with vegetables or meat from the steer, or perhaps they're provided housing. How would you suggest that those types of terms be memorialized in an employment contract?
I think that I don't think anything special or magical needs to be magic words need to be used for those kinds of things. That's consideration. Those are things of value that certainly someone can be compensated with. The thing that I would just note is that, and as being someone who is not a tax expert, is that employees and employers have to know that there are tax consequences of those types of arrangements as well. I think either there's an understanding that there isn't, or there's an idea that people can kind of cut the corners or be a little loose with how they declare certain things as income. And I remember from my tax class in law school, everything's income, So that's just an area where I think, a smart employer is going to get advice from somebody in a tax area who does this type of work regularly, consults with someone like you in the agriculture area, because you just want to make sure, it goes back to the thing we said at the beginning. You just want to make sure you're doing everything right from the start. Spend the extra time and a little bit of extra money at the beginning to do things properly at the beginning. But I don't, to sort of circle back to your question, I don't think those things need to be memorialized in any special or different way. Employers' obligations, employees' obligations. Employers' obligations, employers shall provide housing at, wherever it may be. I guess the only thing I would add is the more specific you can be, what type of accommodations are being offered, what type of food or products are being offered, the more specific, the less opportunity for either side to raise an objection, or at least be able to raise a valid objection. When things are vague is where you run into trouble.
So a question that I oftentimes get are non-compete and non-solicitation clause really enforceable?
Sure. So I do a fair amount of work in that area. Restrictive covenants like non-compete, non-solicitation are absolutely enforceable. Now, there is a big but, right? They need to be enforceable under the law. What does that mean? We'll take non-compete, for example. A non-compete clause typically will have a time and geographic restriction. Time meaning how long may that employee or ex-employee not compete? 6 months, a year, 2 years, 5 years. So 5 years isn't going to cut it, right? That's going to be, and again, this is an area where there's a bright line, but when you do so many cases like I have, you sort of get a sense of what's going to fly. Courts don't want to make someone unemployable. right?
Mm-hmm.
And typically a non-compete is restricting somebody in the area that they work, their main field. So to restrict somebody in their field for more than 6 months, more than a year, certainly, those tend to be struck down as non-enforceable, when you start getting more than a year. Geographic proximity, that also really depends. So, for example, if you do a lot of work in Midtown Manhattan, like I do, 2 blocks can be a big deal, right? There's hundreds of thousands, if not millions of people in sometimes a several block area. If you're in the middle of Montana, I mean, you could have a restrictive covenant that would cover the entire Northwest of the United States that might be found to be reasonable. So it really is a fact-specific inquiry, what's going to be reasonable. But, non-compete clauses that are much more than a year and that force a person to really travel a great distance and incur a lot of expense to really, make a living, those are the types of things that the courts frown upon. It has to be reasonable. It has to protect the employer's legitimate interest and also has to allow someone to make a living. So you want to try to strike a balance. And the one thing I would warn employers about is there's this line of thinking where they would say, well, listen, we're going to say you can't work anywhere in the world for 5 years. We know that's crazy, but the court's going to just cut it down to something less. And that's sort of what's called blue penciling, right? They're going to take out their blue pencil and they're going to mark it up and make it less. More often than not, what's going to happen is they're not going to blue pencil. They're going to strike it completely. So then the employer is going to have zero protection. So my suggestion is, again, work with an employer, work with an attorney that's sort of familiar with your business and the industry, and try to craft a non-compete that's reasonable that a court will enforce to at least give you some amount of protection.
So speaking of working with attorneys, we've got listeners from coast to coast. So how can agriculture producers, agribusiness owners find the right employment lawyer?
I mean, I think in my experience, the best way to find a good attorney is word of mouth. It really is. If you work in the industry, if you work with other attorneys, you'll find that you will get the best referrals by talking to other attorneys you respect. Now, you may not always be in a situation where you can do that. There are bar associations that will give referrals, and particularly where you're looking for someone in a specialized area. I mean, you work in a very specialized area. The fact is, I don't think I even know I know so many attorneys. I don't think I know another attorney that has your particular area of specialization. So, I mean, the use of bar associations, because, for example, someone like you is involved in different bar associations, you will be known for your area of specialization when it's something that's unique, like what you do. But I tend to think word of mouth is the best. I mean, listen, obviously anyone could just go on the internet and put in an attorney in a particular area of law. You might hear that they're like blowing leaves right next to me. I don't know if that's like so loud that you don't hear it. Good. All right, they're getting close. Hopefully, if it's too loud, you let me know and I'll try to move. I think talking to people. I mean, I find that my business is really run on word of mouth. That most of the referrals that come to me are from other attorneys or past clients that had a good experience. So I would talk to people. That really is the best way.
So while people are interviewing an attorney, are there any good questions that you think that listeners should ask?
Well, I mean, I think obviously their experience is important. Have they spent a lot of time in the field that, in the area of work that you're seeking? And maybe talk specifically about your particular situation. Do they have experience with your particular problem or the transaction that you're looking to enter into? Listen, obviously fees are an important part of it. There's a financial responsibility when you're hiring someone to perform services for you. Attorneys are no different. Make sure that you understand the fee arrangement at the beginning. Are they requiring a retainer? How much is that retainer? When does that retainer need to be replenished? I think a very important thing in working with attorneys that I'm mindful of with my clients, and I tell them up front, is that I don't want you to be surprised suddenly with a large bill. There are sometimes there's going to be a lot of work done, and the bill's going to end up getting big. But I'm going to let them know beforehand. I'm going to say, listen, we're in a litigation. We have depositions coming up. There's a trial coming up. There's a lot of work that's going to be put in coming up. I want to let you know, this is a rough idea of the types of expenses that you're going to incur. Is that okay? Do you understand that? Maybe we can work out a payment plan so that you can handle it. I mean, these are all things that I think you want to talk about, the financial arrangement and their experience in the particular area that you're working in. I mean, as you know, there are some really smart and thoughtful attorneys out there, but some of the work we do is very nuanced, and having a comfort level in that particular area is important. You know, I think I'm a terrific attorney, but I don't know the work that you do. I couldn't represent someone in the agricultural industry the way you do. I'm not a tax attorney, right? So, you know, advising a small business on how to set themselves up for tax purposes, I would refer that out to somebody else.
So how can people find you? What's your website? How can people contact you?
People can certainly just call my office, which is 212-869-1040. For not doing tax, 1040 is kind of a interesting. You talked about MMA Lawyer. I mean, people can certainly find me on Instagram at MMA Lawyer, and all the information you need to contact me through there is there. But I mean, if you put in David M. Fish, New York employment lawyer, I'm going to come up. I'm not difficult to find at all.
Well, thank you so much. It's great to see you again. And David and I actually had a 4-day trial together. So he helped me survive my very first trial. So great talking to you, Dave.
Great talking to you. Hope we talk again soon.
Next up, Ask Carrie. Today's question comes from Texas. The rancher writes, I just found out that I have a mediation clause in my contract. What exactly is mediation? So to answer this question, you need to compare mediation with other forms of dispute resolution. So what mediation is basically a neutral third party who sits into a room and helps facilitate a conversation. A mediator is not acting like a judge. That's more akin to arbitration. In arbitration, the arbitrator acts like a judge and hears testimony and looks at evidence and makes a decision that could either be binding or non-binding. It's definitely not court. In court, it's a lot like arbitration and the fact that the judge hears evidence and hears testimony, then it ultimately makes an opinion. The mediator is not making an opinion. A mediator is just there to help facilitate a conversation. If your particular contract, whether it's a farm lease or a bull lease or any other type of contract, has a mediation clause, then basically that is a form of alternative dispute resolution, which would most likely be a prerequisite to going to court, except for if there is an emergency. Oftentimes in contracts, there is an exception that if there is an emergency, you can just skip and go straight to the courthouse. But if you have a mediation clause, then basically you'll be sitting in a room with the other party and a mediator. Sometimes, but not always, lawyers can also be involved. I just had a farm dispute last March, and both parties were there with lawyers along with the mediator. Oftentimes, though, in the family law context, there are no lawyers that are present. So make sure to ask and see if the other party is going to have an attorney, and you're certainly welcome to. So to answer your question, what is mediation? It's basically you're there having a conversation with the other party, and it's directed by a neutral who is going to help facilitate a conversation. And it could be several mediations sessions in order to reach a resolution. I had a mediation a few years ago between an agriculture producer and several disgruntled members of the community. And I believe that we had 6 mediation sessions over a course of about 5 or 6 months. So don't think that in an hour sitting everybody in the same room is going to solve it. It might take a few different sessions. And if you have a question for the Ask Carrie portion, please be sure to email me at Carrie, C-A-R-I, at rinkerlaw.com, spelled RINCKERLAW.com. Again, you can email me at Carrie at rinkerlaw.com.